today, you change your mind and you want to have a lawyer, you'd be free to apply at the public defender, to hire a lawyer on your own, or to represent yourself.
And 24 CM 1859, the state is requesting the standard non-monetary conditions. In case 24 CF 1919, the state is requesting no contact with deputies Larry O or Andrew T. Except for legitimate law enforcement purposes. This for cat bills, the defendant is continuing to violate court orders, committing crimes, despite his incarceration. The state put up with it that we don't have a choice other than to retain you to ask for a cash bail.
And it looks like he's on a $1,500 cash bail on the other open case, which is looks like resisting causing soft tissue injury.
Oh, I believe that's correct.
Did you want to speak more to why 750 is now an appropriate number on these charges?
If the defendant hasn't been able to post the previous amounts, I'm not sure what the effect of doubling that or going above that is. I can't speak to the motivations by the reviewing attorneys other than to point that out to the record.
All right, and Mr. Lytle, what's your position regarding bail in these two cases?
It doesn't matter what you set the cash bail at because I'm not going to be able to pay it, and I'll be entering a plea of NGI due to the fact that the deputies have, not just in these cases, but in previous cases, allowed me to bang my head for up to 15 minutes straight at a time, and I have no recollection of these days.
Okay, well, that's certainly your right to enter that plea. That's not an issue. So here's how I see this. If a $1,500 cash bail was appropriate on a case where he's alleged to have engaged in resisting, causing bodily harm, I can't figure out why setting bail at half of that on 3 new charges, 2 of which are essentially the same or more, maybe even more intentional sort of behaviors, would be appropriate. I'm not prepared to do that. I'll set cash bail at $2,000 in 1919. I'll set it at $300 in the misdemeanor case. I think the requested conditions involving contact with those 2 deputies, except in the course of their professional duties, is appropriate. Mr. Lytle, I think in your earlier case, perhaps you waived the time limits for preliminary
I
hearing.
did not.
You did not. Okay, good. Then we'll make sure they're enforced in this case. In the felony case, we'll get that put on within the next 10 days.
What about my plea for NGI?
Right, so that's a little early for that plea. That has to happen at or around the time of arraignment.
It is not too early for that plea.
Okay, so actually, you know what?
If you want to argue with me, I'm more than happy to prove the fact that I'm encountered by cussing your bitch ass out because you don't want to do your fucking job and accept my goddamn NGI plea.
Actually, I think you might be right about the misdemeanor case. I think it probably is an appropriate time for that. We'll go ahead and accept your bifurcated plea of not guilty and not guilty by mental disease or defect. I think I'm going to defer to the assigned judge whether to order an evaluation and under what circumstances, and we'll inform him of the need to do that. It is too early to do it in the felony case, and you're certainly welcome to take up that issue in an appropriate fashion with the assigned judge or the judge who hears the preliminary hearing. That's not a problem. We'll get that case.
I mean, my fucking NGI plea. I haven't done on all cases.
Okay, we're done for today, Mr. Lytle. Good luck to you. We'll get it scheduled for a timely prelim on the felony. Take care.
So we did 2,000 on the felony and 300 on the other one.
Yeah.
I just need one back.
Sure.